Good morning and welcome to the meeting of the Metropolitan Board of Ethical Conduct. Today is September 30th, 2021, and it is 8:30. And we will now call this meeting to order. I will ask our Board Secretary, Ms. Waits, to take the roll.
Ms. Carpenter?
Present.
Ms. Diani?
Present.
Ms. Mohan?
Present.
Mr. Patton?
Present.
Mr. Rosenberg?
Present.
Ms. Stewart?
Present.
All members are present. We have a quorum.
Thank you. Our first item on the agenda is the approval of the minutes of our March 8th, 2021 meeting. Everyone should have the minutes in their package. Why don't I get a motion on approving it? I'll get a second and then we'll have any discussion.
Motion.
Second.
Okay. We have a motion to approve the minutes of March 8th, 2021. We have a second. Is there any discussion? Hearing none, I'll ask our Board Secretary to take the roll.
Ms. Carpenter?
Approved.
Ms. Diani?
Approve.
Ms. Mohan?
Approved.
Mr. Patton?
Approved.
Ms. Stewart?
Approved.
And then the pro tem is a non-voting member.
We'll move to item 3, which is notice of appeal rights, and I'll ask our Board Secretary, Ms. Waits, to provide that notice.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek an independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. We now move to item 4 on the agenda, election of a vice chair, and this is a good time to mention that we have a new member with us, Ms. Diamond Stewart. Ms. Stewart is with us and will be a member. Because her predecessor left, who was vice chair, so we now will be electing a vice chair. We will do that by nomination, and I'll ask everyone to remember that they may nominate themselves if they wish to serve as vice chair. So, are there any nominations for the position of vice chair?
I leave the door. I got too much going on. I leave the door for one of them.
Okay,
Yeah.
thank you.
Could we hear a little about the role?
Yeah,
That might help.
Always be informed consent,
Yes,
yes.
Yes,
exactly.
in the event that the chair was not available at a meeting, then the vice chair would run the meeting. Is there anything else that you think that we should add, Metro Legal?
No, that's
Okay.
pretty much it. Okay. I really should not do this, but I will be happy to serve if nobody else would like it to.
In that case,
So I guess I will nominate myself begrudgingly.
well, thank you.
Yes, you're welcome.
In that case, I will formally propose a nomination of Ms. Carpenter as vice chair. May I have, I'm moving to nominate Ms. Carpenter as
Second.
vice chair. May I have a second?
Second.
Second. Any discussion? Okay, hearing none, I'll ask for a roll call vote.
Ms. Carpenter?
Yes.
Ms. Diani?
Yes.
Ms. Mohan?
Yes.
Mr. Patton?
Yes.
Ms. Stewart?
Yes.
5 in favor, none against. Motion passes.
Okay, we now move to the 5th item on the agenda, discussion and analysis of the complaint and Metro Legal memorandum in the case of Philip V. Hall. And I think we can start that. I will say that everyone should have a copy of the complaint filed in this case, along with the exhibits to the complaint, as well as an August 12, 2021 memorandum by the Department of Law, its report on the complaint. And I hope everyone's had an opportunity to read it closely. And I will ask the Law Department, Mr. Dietzer, to just briefly review for us the memorandum and its conclusions, and then we'll have an opportunity for members to ask questions and so forth and move into discussion. Thank you.
Sure.
There are two main allegations in the complaint. The first allegation is that the council member failed to file all disclosure statements required by the Metro Code with the clerk. The standards of conduct require council members to file disclosure statements by January 31 of each year with the Metro Clerk. The disclosure statements cover financial information for the preceding year. Information to be disclosed includes sources of income, certain debts, positions held, and financial interests in businesses and real properties. It is alleged in the complaint that the council member filed a disclosure statement in 2020. Allegedly, no disclosure statements were filed by the council member in 2019 and 2021. The Metro Code states that an employee shall not fail to file in a timely manner all disclosure statements required by the standards of conduct. It is the opinion of the Department of Law that the allegations concerning failure to file required disclosure statements with the Metro Clerk, if proven true, will constitute a violation of the standards of conduct. Therefore, the Department of Law recommends that the board hold a hearing on the allegation that the council member failed to file required disclosures with the Metro Clerk. The second allegation in the complaint is that the council member failed to file conflicts of interest disclosure statements required by state law with the Tennessee Ethics Commission. State law requires candidates for the Metro Council to file conflicts of interest disclosure statements with the Ethics Commission. As long as a council member remains in office, the council member is required to file amended conflict of interest disclosures by January 31 of each year. Information to be disclosed includes sources of income, lobbying activities, bankruptcies, investments, and loans. The complaint alleges that the council member failed to file conflicts of interest disclosures with the Ethics Commission in 2018, 2020, and 2021. The Tennessee Ethics Commission is the entity that administers and enforces Tennessee Code provisions concerning conflicts of interest disclosures. Information in the complaint indicates that the Ethics Commission has addressed the alleged failure to file 2018 and 2020 disclosures by issuing civil penalties to the council member. Information in the complaint also reflects that the Ethics Commission is already addressing the council member's alleged failure to file 2021 disclosures. State law specifies that information concerning failure to file state disclosures are under the jurisdiction of the Ethics Commission. Therefore, the Department of Law recommends that the board dismiss, for lack of jurisdiction, those portions of the complaint dealing with failure to file disclosures with the Tennessee Ethics Commission.
Thank you. Thank you for that very clear summary of the memorandum, again, which we've all seen. We can open it up to discussion now. I guess I'll first ask members if anyone has any questions of the law department regarding the analysis of the memorandum or its conclusions. No questions? Okay. Since there are two recommendations and conclusions in the memorandum, perhaps we can discuss each one separately as a distinct claim. We perhaps can start with, I think, the first, and at this point, what we are doing is we'll be discussing it, and in order to come to decision as to whether we will adopt the recommendations of the law department or not, and if we adopt the recommendations, what the next steps are. So that's our process and what we're discussing now. With respect, if we take the second item first, which is what the law department recommends should be dismissed for lack of jurisdiction, is there any specific discussion regarding that? I will say that my understanding of a jurisdictional question is that to the extent the allegations relate to a failure to file with the Tennessee Ethics Commission, that is the Ethics Commission which has the jurisdiction to enforce that, and that clearly is not within our jurisdiction. Our jurisdiction speaks to the standards of conduct under our Metro Code. So there seems to be very little question as to our lack of jurisdiction on that second item. Having said that, I guess does anyone disagree with that or have questions or concerns or
No.
how they
Yeah,
would?
it seems clear.
Oh, okay.
Good.
So why don't I entertain a motion to adopt that portion of the Law Department's memorandum, which is their recommendation to dismiss the second allegation regarding the failure to file the requisite conflict of interest disclosures with the Tennessee Ethics Commission on the basis of lack of jurisdiction.
Motion.
May I have a second?
Second.
That motion, we have a second. Is there any discussion? Hearing none, I'll ask our board secretary to take a roll call vote.
Ms. Carpenter,
Yes.
Ms. Deani,
Yes.
Ms. Mohan,
Yes.
Mr. Patton,
Yes.
Ms. Stewart.
Yes.
5 in favor, none against, motion passes.
So we hereby are adopting the recommendation of the Law Department's memorandum and dismissing that portion of the complaint. We now turn to the first allegation regarding the alleged ethical violation under the standards of conduct under the code, which is where our jurisdiction lies. And again, that is under the code, chapter 2.222, standards of conduct, disclosures of interest, and enforcement. That is our section of the code which relates to our authority. The standards of conduct, I hope you've all had a chance to review them and are familiar with them, are set out in code section 2.222.020. That is the standard of conduct that we are charged with enforcing. And 2.222.030 is the provision regarding the disclosure requirement. And in the disclosure requirement, I hope everyone has had a chance to review that. There is actually a form in which the disclosure to the Metropolitan Clerk's office is laid out, set out within the body of the code itself. That said, let's have discussion as to this first section of the Law Department's memorandum regarding its recommendation that, again, if the allegations are proved to be true or established, then it would be a violation of the standards of conduct, which is within our jurisdiction. Let's have discussion of that. Again, any questions or discussions or comments that the board wishes to share?
I'd like to ask a question, just for procedure. What we are determining here on this first issue is whether to hold a hearing, is that correct?
Yes, only to hold a hearing, to
And-
move forward on it.
To move forward with the
This
hearing
is
based on the
tantamount-
recommendation.
It's
Okay.
tantamount to a motion to dismiss,
Understood,
and
okay.
whether it's,
And would that hearing be today or at a
no,
different
it would not be
date?
today. It would be
Okay.
scheduled to give all parties an opportunity to prepare, to understand what our hearing procedure would be, to give them adequate notice so they can make whatever presentation they wish to make. So it would not be today. We would schedule it after the vote if we are going to go forward to a hearing. The other question is exactly the scope of the hearing. Again, to give everyone notice of what the issues that we'd be considering, what the nature of a alleged violation of the standards of conduct are, so that people understand, both the complainant and the respondent have fair notice of what we are considering. as a potential ethical violation under the code. So those are the two things, really, whether we would go forward to a hearing, and secondly, exactly to articulate the scope of that. And on this second point, this question of scope, and I guess I will actually ask the question to the law department. Our charge, we live within the standard of conduct. One of the elements of the standard of conduct is complying with state law that's required of any elected official. It's 2.222020, I think it's M. A employee, and in this case, an elected public official, shall not violate the direct or indirect conflict of interest, consulting, lobbying, or any other requirement of state law existing or which may be adopted regulating the conduct of municipal or county officials or employees. So under section M, is it the law department's view that that would be within our jurisdiction to consider if we move forward to hearing that question under that that paragraph of 2.222.020. Questions clear?
Okay.
So I guess literally I'm just thinking about giving adequate notice, and if we're going to go to hearing, actually delineating which elements of the standards of conduct and the requirements we are going to be looking at. So I want to make sure that we can be as precise as to the scope so that everyone has full notice.
Yeah, the specific provision with regards to the first allegation is the subsection 2.22020 R. And that's the provision that says if disclosure statements are required to be filed by the employee in accordance with this chapter, that the employee shall not fail or refuse to file in a timely manner all disclosure statements and reports. So that's the specific provision.
Okay, so it is R that
Correct.
has been alleged in
Yes.
the complaint, and that we will stay within that scope.
Correct.
If we decide to go to hearing. Okay, so
Yes,
that's very
just the
clear.
issue of whether or not disclosures were filed,
Okay.
and were filed in a timely manner.
Okay. Just,
Would it be proper to hear from the council member, or is that?
I'm going to defer to our board secretary, that we usually see more motion. It's a legal question.
Right, no testimony is taken at these hearings. This hearing is just a meeting to determine whether or not the board will hold a hearing.
So should I go ahead and?
When is it issued? There are some procedures on our website that I'd be happy to pull up really quickly. They go into a little bit more detail if the board adopted with respect to what kinds of materials would be considered at this stage of a proceeding.
Got it, okay, thank you.
If I may add a couple of things, for the lawyers in the room, this is very much akin, as Ms. Carpenter said, to a Rule 12 motion to dismiss. At this stage, we take the allegations as true, and the standard for the law department in the memo as reported was, if proven true, would that be a violation? And that's the reason we recommend going to a hearing, at which point, at that hearing, evidence can be taken whether or not there has been a violation. And on the technical question of whether, the chair's question about whether this body, whether this board has jurisdiction for violation of the conduct about any applicable state law. Technically, the board does have jurisdiction over those, but as we've already reported, those allegations have been addressed by the board that has primary jurisdiction, and they have been resolved with disciplinary sanctions. And so there's no reason for this board to move forward with hearing that, since the board with the state board with primary jurisdiction has already acted on those allegations and entered sanctions as it deemed appropriate. So there may be other circumstances where that question comes up where it is appropriate for this board to review those allegations. But we suggest that the scope of the hearing be limited to the first allegation of the complaint.
Thank you for that clarification. And I will say that I do think it was a point to, we certainly don't want to give the misimpression to the public record that we do not, as a body, have jurisdiction over an elected official violating a state law as an ethical question, not substantively as a violation of that state law, but as an ethical question.
Well stated.
As for Metro Department. So I just wanted to clarify that we are not suggesting we don't have jurisdiction as to that point, but given your explanation in this circumstance, and given the recommendation of Law Department, you're recommending we look at this question as to the question of our section R in our standards of conduct as to failing to file the annual report exclusively.
That is correct.
Yes, okay. All right, so given that that's the Law Department's clarification, is there any other discussion?
No. Me.
Okay, great. Okay, so why don't we entertain a motion to adopt the Law Department's memorandum with respect to the first allegation as to failure to file the annual disclosure statement to the Metropolitan Clerk's Office.
So moved.
Second.
We have a motion to adopt. We have a second. Is there any discussion?
I just want to clear, the motion is to move on to a hearing.
The motion would be to adopt it, the right recommendation, which is that we move to a hearing.
Okay, I just wanted to make that
Yes.
clear for the record.
Yes.
Okay.
Okay, hearing no discussion, I'll ask the board secretary to take the roll call vote.
Ms. Carpenter?
Yes.
Ms. Deani?
Yes.
Ms. Mohan?
Yes.
Mr. Patton?
Yes.
Ms. Stewart?
Yes.
5 in favor, none against. Motion passes.
Thank you. Okay. We have adopted the recommendation. The motion is to move on to a hearing to determine whether the allegations can be proved as to a alleged violation of our ethical standards under our code section. So at this point now, it really becomes a matter of logistics about preparing or scheduling a hearing. I hope everyone has calendars with them. When we are scheduling a hearing, we consider questions of practicality and logistics, and certainly opportunity and for all parties to prepare the case. It would seem to me, and I'm happy to entertain discussion on it, it would seem to me that this is a fairly narrow scope and a hearing on it in terms of establishing proof of a case would be fairly narrow. We're not, I don't believe, looking at witnesses and extensive documentation. So I think that we can consider a nearer-term hearing to get the matter moved and resolved in kind of short order. Again, I don't think we're going to have long submission lists. That said, I think that there certainly should be a minimum amount of notice, and we also have our schedules to deal with. So I guess I would propose, and open to discussion and considerations of other factors that I might not be considering, I would propose to be looking at, tomorrow is October 1, for 4 weeks, around 4 weeks. So we'd be looking at the last week of October. I do think, and I will defer to the law department or our board secretary to ask, since we have, I believe, the respondent and the complainants here, may we take their schedule into account?
Absolutely.
Yeah, I would really
I'm not
wish to-
aware if the complainant is here, as I've not met him before, but.
Okay, I'm not, I believe so. So I think, out of respect for the parties, I would certainly like to hear from them about
Definitely.
their schedule and their time needs in preparing to go to a hearing.
At your convenience, ma'am.
Okay? Same, okay. Is there a minimum amount of time that you would like to have? I guess I'll address my comments to the. Whatever works, okay. So if you look then at the last week in October, October 25, we look at that week. And I will also, we'll need to take in the board secretary's schedule and council meetings and so forth, what looks potentially available.
We certainly have rooms available and could meet on either Monday or Thursday with a lot of availability.
I'm going to propose that Thursday then, Thursday, October 28th. Is that possible?
Would this be an 8:30? Or
Not
is
necessarily.
it flexible?
Yes.
Okay. I'm available.
And I don't have you all's schedules pulled up right now. Okay. Do you need me to, or do you have it?
Yeah, that's fine.
Okay.
That's fine with me.
Mr. Patton?
I'm good.
Works for me.
Okay, so the time then, it sounds like we have flexibility, and it may depend on the room availability.
We're good.
All day?
We're good all day.
Do any, either parties have any restrictions or preference in terms of time? Shall we do it then? Is 8:30 is more complicated for you?
No, that's
Let's do it
okay.
at 8:30 then. Get it done. So we are now proposing, based on input from everyone, that we hold the hearing on Thursday, October 28th, 2021, at 8:30 in the morning in this room. In this room. We have procedures, I believe, on the website.
Yes, and I'm looking at those. I wouldn't mind just going over them.
That would be
briefly.
wonderful, yes, thank you.
So, when the board has called a hearing on a complaint, the hearing shall be conducted as follows. If the hearing shall be noticed and open to the public in accordance with these procedures. Notice of hearing shall be provided to the complainant and the members or officials named in the complaint. So that'll be provided by our office to the parties. The parties may, but are not required, to submit materials to the board. If a party does wish to submit materials to the board, the party must file the materials with the Metro Clerk's office and provide a copy to the other party at least 7 calendar days prior to the hearing. The clerk shall provide a copy of the same to the board members in the Department of Law. The parties shall have a full and fair opportunity, but are not required, to present their positions and facts to the board at the hearing. Each party has the right to the assistance of legal counsel. Each party shall be allotted a reasonable amount of time to make its presentation to the board. All parties may call witnesses to give testimony at the hearing, which testimony shall be given under oath, with the witnesses stating their legal names. All witnesses will be subject to cross-examination. Each party must file with the clerk a list of witnesses that the party intends to call at the hearing and provide a copy of that to the other party at least 7 calendar days prior to the hearing. At the hearing, no party shall be permitted to call upon any person to give testimony if that person's name was not included on the list. However, the board may permit an unnamed witness to be called by a party if, in the board's judgment, there was good cause for not timely naming the witness and the other parties would not be unduly prejudiced. Board members may ask questions of any party, counsel, or witness at any time during the hearing. The board may, in its exercise of its discretion, permit interested persons to present at the hearing to persons present at the hearing to offer testimony under oath. So the board may allow interested persons present at the hearing to offer testimony under oath, even if those persons were not called as witnesses by either party. The board may continue a hearing to a later date. The director of law or metropolitan attorney shall be present during the hearing to advise the board.
Thank you. Okay, I'm gonna ask the lead, would you prefer that we vote for the date, or can we, that's not necessary?
That's not
Okay,
necessary, the
okay.
clerk can
Okay,
organize
just
that.
get- okay. Okay, so I think, is there any other discussion, any questions about either the procedures or the scheduling from board members? No? Okay.
Nope.
So hearing none, I think we can entertain a motion to adjourn. This meeting is complete. Our business today is complete. May I have a motion to adjourn?
Motion.
May I have a second?
Second.
Okay, any discussion? Hearing none? Take a roll call vote. We did online, maybe it's not necessary at this point. Okay, so we will then skip with the WebEx procedure and go straight to the in-person procedure. This meeting is now adjourned. Thank you.
Thank you.